Good morning. While reading books, I was always in search of a case which could help you practically during current period so that you can have some benefit of my this interaction with you. Here today I have another case wherein a new trend was introduced by Supreme Court by deviating their earlier judgment whether checks issued for security purpose would be ignored for prosecuting the defaulter in arranging for sufficiency of fund after having issued those checks. Prosecution under 138 is maintainable or not. So I would like to, prior to referring the judgment, I want that there are multi-number of financial institutions, check funds, so many other person dealing with financial transactions, wanted advocates. So they all want an advocate to prosecute their defaulters, particularly in check cases. Probably a meager amount of fees may be paid to you, but as you always expected, may not be a high fees. But still, if you have currency of dealing those cases, you may be more skilled in one particular field, and that may help you to develop your advocacy also. That is up to you to decide it. For that purpose, you have to keep this judgment 138 negotiable new amendment of claiming after framing charges. You can claim interim compensation and delay in condoning the days in preparing the complaint. All those things, the new amendment and these judgments on your fingertip. In this judgment, there are other few judgments were referred about this issuance of check for security purpose. So I will now refer the judgment. The judgment is running multi-number of pages, but you have to go through all the paragraph if you are really interested to be a master in check bounce cases. AIR 2021, Supreme Court 5732. Sripati Singh, since this is through his son, Gaurav Singh versus State of Jharkhand. See, here the case was 420 IPC also and 138, 190, 245, all these things are there. The accused claiming that he has issued checks only for security purpose, so that default of those checks being presented, he is not liable. So discharge application was filed and that was rejected, but High Court filed applications. Allowed it for the respondent to. Here the question was, first of all, they have read AIR 2017 5327 Samir Sahani alias Samir Sahai case, very starring case, and Sudhir Kumar Balla, another case. Here they say they want the question whether a post-dated check is for discharge of liability, debt or liability depends on the nature of transaction. If on the date of check liability or debt exists or the amount has become legally recoverable, the section is attracted, not otherwise. Then you see the check issued as security pursuant to a financial transaction cannot be considered as worth piece of paper under every circumstances. Security in its true sense is the state of being safe, and the security given for a loan is something given as a pledge of payment. This is what they say. They say the check which is issued as security would mature for presentation, and the drawer of the check would be entitled to present the same. On such presentation, the same is dishonored. The consequences contemplated under Section 138 and other provisions of NI Act would follow. Then they say, and also they say, in any event, it is not for the drawer of the check to dictate terms with regard to nature of litigation. You may not say that you can only file civil case, not criminal case. Finally, they say, it is issued an assurance to repay the amount after the debt becomes due for repayment. So in a given case, since he has defaulted, the 138 is maintainable. But they say 420 is not maintainable. For that, they have certain observations. Since it is for that, they have lot of discussion whether here is say, from the above aforesaid facts and documents of the court finding that long-standing business transaction and the inability of refunding of loan has been given a color of criminal offence of cheating punishable under Section 420 IPC. A breach of trust with mens rea gives rise to criminal prosecution. In this case, when I go through the evidence before the charge of the complainant and the document, I find there were long-standing business transactions between the parties. Since 2011, money was advanced by complainant and his family members to the accused, and the complainant witness admits that money was also transferred from the account of the accused to the account of daughter of the complainant. From the evidence, I find there is no material to suggest existence of any mens rea. Therefore, no case punishable under Section 420 IPC can be made out in this case. This is what their judgment. So you have to be careful about that. So then, what about my experience? What to do, what not to do? So you have to apply your advocacy mind and the experience mind after getting instruction from your client stating that these checks were obtained even prior to date of the existing debt, and by taking advantage of retention and detention of those checks, they have misused it as if it was given for the present debt. So that will be your very apt defense. That should be answered in the reply notice. Unfortunately, the modus operandi of complainant is they neither pay the financier after having debt, nor pay the advocates, nor even hesitate or inclined to go to advocate to reply, simply thinking that he will manage, he will manage, he will manage. So kindly take if it is that was the case of the parties, we can't help them. However, at the time of filing or cross-examination, you can suggest that you can also try to elicit through your experience cross-examination or calling for the records from the bank and searching for the bank transaction, that what well are the checks issued by him after the date of transaction, present transaction in dispute for 138, and the checks dated, checks numbers, subsequent numbers which were given earlier. That will be apt play of defending 138 negotiable instrument act. So this is for defense sake. If you want to prosecute, if you want to lead a normal life, my humble submission is that don't run always after the money. You increase your caliber, increase your intelligence, increase your skill, increase your law knowledge, then money will definitely come to you. As recent rain reached Chennai, one day or other day, or one season or other season. I hope you understand my feeling. Best wishes. Today, Puratchi Thalaivar M.G. Ramachandran's birthday. His birthday was being celebrated because after sustaining firearm injury, he reopened his eye, and that was his birthday. And everybody said that was his birthday. We accepted it. After all, he is a godly man. See, my contact with Puratchi Thalaivar MGR was that first I went there and Satya Studio. Then everybody wants MGR should start a new political party. Then that was me. I will be the one. I am at a very tender age. I will be the one, 19 years. I will be the one who suggested that Anna Dravida Munnetra Kazhagam. Thereafter, what had happened? I was one of the prominent student leader. When he constituted a committee, Needi Goru Manavar Poratu, I was one among them. I was arrested and confined. I was appointed as executive committee council when I was under the age of 19 years. Thereafter, what had happened when I and another Pachaipas College student Murthy declared pass in BA examination, he invited us, gave feast and given a 5-star chocolate. Thereafter, on several occasions, we had an occasion to meet him. Unfortunately, thereafter I got central government employment. I went, and on one occasion, I had an occasion to see MGR when he was attending CPP Rajavedu, the brother-in-law of Ka Rajaram, his ministry cabinet. He was at that time, since suffering from some injuries, some ailment, he was remaining silent. And my child, Alamelu Sarutri, was on my shoulder. She is very young, 2.5 years. She simply shown Puratchi MGR and told him, Appa Bommai, Appa Bommai. He says, Dad, here is a toy, here is a toy. Then I immediately tried to leave him. Then that time Justice S.T. Ramalingam. Meeting was over. S.T. Ramalingam called me and told me, Hi, doctor, how are you? See, I know only one doctor in Tamil Nadu, that is you. He said, further things I do not want to convey that all those things. However, I had an occasion to meet several holy people. I personally saw Radhavacharya, Rajaji and Ivera Periyar, then Mr. Nedunjeliyan, Mr. Karunanidhi, the then Chief Minister. I went inside his home and he was anxiously waiting for the result of the Congress alliance. And Mr. Karuppan took me to there only to support his approach to meet Mr. Karunanidhi. That time I stood behind him and my hand touched on his head. I felt sorry, but I hope that subsequently lot of changes occurred in Tamil Nadu and he became Chief Minister of Tamil Nadu. That thereafter, you see, I met several times Madam Jayalalitha when I was attending on behalf of Sasikala Madam before the special court. My another child, Narmada Stephy, who is a doctor and now residing at Dubai, I took her very young. She was about 8 to 10, 11 years with the robe. She took her and she thought because I am wearing this Tirumanjanam, spoken with my Narmada Stephy in Telugu and blessed her. These all are occasions I had. It's all right. I am happy that I had an occasion to meet Atal Bihari Vajpayee, Ram Vilas Baswan, and so many, Uma Bharati, Tarageswari, Sinha. And I want to meet yet another leader, that was Pragya Thakur. I printed a calendar when she was jailed in connected with the Malgaon case. She had a courage to do certain things. It is remarkable. That is freedom fighting mentality. I am always there. Best wishes.